you so much, and thank you for the nice introduction. You know, we normally do, or many of you may have already taken our other class that talks about screening new tenants and new buyers. We don't often do this class, which I feel is a supplement to that. The first class talks about the authority to screen and what you can do, you know, what your governing documents say with respect to approvals and transfer approvals and what have you. This one is more, it's listed as an HR credit. So I know a lot of you need that, and that's coming to the end of the cycle for your reporting purposes. But I also feel like this gives a little bit more of a hands-on type of approach to dealing with the screening process. So I want to begin defining the role. Obviously, one of the most important things for you as community leaders and you as community managers is to identify who's going to actually be serving in the role of the screening committee, whether it's a subset of board members, whether it's your manager is going to participate, whether you have separate people to do so. And then you have to evaluate the authority in the governing documents. Do you have a right of approval or a right to approve or reject? Or do your documents simply have a right of first refusal or a right of substitution? That's a threshold question. And a lot of my clients are surprised to learn that they've been screening and going through this process year after year for forever, and they really did not have the legal authority to reject purchasers, and in a lot of cases, even tenants, because the old documents, if they were never amended, had that right of first refusal or that right of substitution, not only when it came to sales, but also when it came to tenancies as well. So if you have the right of approval, you know, on what grounds can you approve? I mean, a lot of times you'll see in the documents, I see this all the time, and it's somewhat comical that there's unbridled discretion or the sole, you know, decision-making on the part of the board of directors, whose decision shall not need to be revealed, or there is no reason to provide for an explanation. Well, you know, that's just not going to cut it. That doesn't really cut it in the modern world. Where do all these things come from, and why are there limitations on screening or the ability to reject transfers, the ability to say to a current owner, hey, we don't like your purchaser, we're going to reject the transaction altogether? And to a lesser extent, tenancies. Well, I'll tell you, both in our federal and our Florida Constitution, it protects the right of alienability of property. So one of the big things that we learned, or that this country wanted when it broke off from the UK, was the ability to hold property and to have discretion as to what you do with your own property. If you want to sell it, if you want to lease it, if you want to develop it, if you want to keep it as private, undeveloped land, or what have you. So this right of alienation is a paramount right. It obviously and supersedes your declaration of condominium or your declaration of covenants. And the question often is when does the board of directors have the ability to reject a transfer, meaning a sale? And is that rejection conditioned upon purchasing the unit or substituting a purchaser? Because here we're protecting the current unit owners. We're saying to the unit owners, hey, listen, the association may have the right to screen and approve your purchasers, but we're not going to punish you, current owner. We're going to make you whole by substituting in another purchaser or purchasing the property so that you get the value of your deal. And this actually came to fruition, or the battles heads back in many years ago in Florida in a case called the Aquarian Foundation versus the Shalom House. The documents did say that the board had, quote, unbridled discretion to reject a transfer so long as it had the obligation to purchase the property for the then fair market value. The court said this: When the declaration of condominium in the present case permits the association to reject perpetually any unit owner's prospective purchaser for any or no reason, such a provision, so obviously an absolute restraint on alienation, can be saved from invalidity only if the association has the corresponding obligation to purchase or to procure a purchaser for the property from the unit owner for the fair market value. So again, you need to obviously evaluate what authority that you have in your governing documents. Do you have the right of approval? Do you have the ability to reject without triggering any corresponding obligations? And how is that actually recognized? Also want to recognize some special circumstances. Special circumstances could be if there is an intrafamilial transfer, a transfer or a sale that is not based upon fair market value. There's some kind of relationship that lowers the value or lowers the consideration for the purchase. And you want to be cognizant of what your documents say when it comes to the timeline. I can tell you there a lot of things in the law are pretty flexible, but compliance with the timeline when it comes to this very, very important procedure is of utmost importance, because there have been arbitration decisions, not cases of which I'm aware in Florida, that basically have rejected all reasoning if the association did not act on a timely basis. For tenancies, you're in a little bit of a different situation. Tenancies are not protected by the Florida Constitution, so you can have an absolute restraint if your documents prohibit tenancies altogether. I mean, tenancies are not going to be approved altogether. If your documents have limitations on tenancies, like a waiting period for 1 year before you can lease or you can rent, or caps on tenancies or minimum terms and the like, those are more easily enforceable, or more readily enforceable, because they do not involve any constitutional protected activity. And then you want to communicate the process. If you, as a property manager or the board member that's training your screening committee, you really want to have a process in place with the timeline, and to communicate that process not only to your screening people, but to the parties to the transaction, so that everyone is on the same page. They know if they submit the paperwork today with their check, it's a 30-day turnaround, so they can actually calendar the 30-day turnaround. In some cases, you're going to request additional information. You may modify or extend your timeline based upon the request for and the receipt of that additional information. You need to have that memorialized somewhere. So when you are requesting additional information, you're going to say, we need X, Y, and Z. You failed to include a copy of the contract or some other reason. And therefore, our period for reply is going to be extended based upon this additional information. Jeff, is there an issue or?
No, just a quick question. I want to make sure my screen's not frozen. Which slide number are we on? I'm still showing defining the role slide. Is that correct?
Exactly. So
okay,
we're moving right now to the next slide on
thank
our.
you. That's all.
Okay, great. And special circumstances. So what kind of special circumstances do you need to be aware of? Military service. Now, when you're dealing with somebody who's in the military, then you must respond to an application for rental approval within 7 days. There are special rules dealing with the military. But what about if the owner or the tenant, the prospective owner or the prospective tenant wants a reasonable accommodation? Meaning, emotional support animal or some other type of an accommodation, a parking space because they have a handicap disabled placard, or they need an accessible route to get back and forth to their parking space. Well, you are obviously going to request additional information in connection with those. Is your timeline exactly the same? Probably not. Your documents probably don't create an absolute timeline for approving either a reasonable accommodation or a reasonable modification, but that's where your communication comes in. If there are additional issues that need to be addressed in connection with the transfer approval application, you're going to want to separate those additional approvals from your timeline for the approval or the rejection or the right of the substitution with respect to the actual tenancy or purchase. And you can explain that you're responding on the purchase, but you're not responding on the accommodation. Now, reasonably, someone in that situation would say, well, listen, I don't want to close, or I don't want to, move into the apartment as a tenant until I know that you are going to grant my accommodation or grant my modification. So in those cases, you do want to memorialize any extensions, and so that the real estate agents involved aren't all over your back because the timeline for closing has passed or some other circumstances. When you're dealing with accommodations and modifications, of course, you have to be diligent in the investigation, the meaningful review of the requested accommodation or modification, but more likely than not, you will request additional documentation or additional information, or may need to speak to someone. And if that's the case, still need to comply with the timeline for the approval or for action with respect to the transfer itself. So what is on your timeline? Well, as soon as it comes in, you verify that the application is complete, and you make a note somewhere of the intake date. Does the application have all the documents that are necessary to include with the application? A copy of the contract being one of them, driver's license, other identification reflecting the previous residency or what have you. If you are entitled to, you can order your consumer report, you can schedule your interview, and then of course you have to notify the member or the applicant within the time period that's prescribed by your governing documents. Please do not ignore the timelines in your governing documents. What kind of fees can you charge? I often hear some mistaken impression when it comes to what is chargeable in connection with the transfer approval process. There are very limited. There are limits on fees. The screening investigation fee has been increased. I apologize. I believe it's $150 now because it did increase. But you have to limit, that is for the screening investigation background application. Security deposits are permitted with respect to tenancies only if your documents so provide, and the security deposit cannot exceed 1 month's rent, but your documents may have a different figure. It may say $500, may say $1,000 or what have you. There are fees associated with the estoppel certificate. That's in connection with a sale, not a tenancy, and those fees are prescribed by statute. In fact, as of July 7th or so, the DBPR increased the fee that's permitted for an estoppel request. What about mortgagee questionnaires? If you've been following anything that's going on with the news, you know that the Fannie Mae, Freddie Mac, and GSEs have completely revamped their mortgagee questionnaires to ask all kinds of intrusive questions that you may not be capable of even answering, because a lot of it requires some speculative information. And those are all promulgated on a temporary basis. But that all being said, as a community leader and community management, you want to do whatever you can in order to facilitate the actual transfer. You don't want to forestall your owners from being engaged in the marketplace, because that's only going to be to the detriment of the association and the detriment of all the other owners. So obviously, mortgagee questionnaires are a hot topic item right now. What you include in them, what you choose to exclude, and how you respond are all very important in order to preserve the ability to maintain the marketability of the property, but also not to put yourselves out on that limb. I can tell you what I've done with very few circumstances is take one of the questionnaires and provide the client with specific answers that are appropriate for that particular property. And a lot of it is contingent. If you had an inspection report, you're obviously going to provide it. If you've been notified of a code violation, you're obviously going to report it. But if you haven't, you want to word your answers very, very carefully. Move out, move in, move out fees. Fees generally are not applicable for move in, move out. Generally, you're going to have deposits, but there has to be some authority for it. Same thing with regard to the preparation of the elevator and other expenses that you may incur. Sometimes fees are appropriate, sometimes they're not. It just depends on what your governing documents say. And are you collecting a deposit or a fee? Deposits are more than likely going to be acceptable so long as your rules have been properly promulgated. Fees are a different ball of wax altogether because the condo statute does prohibit fees under certain circumstances. Now, we were hearing particularly in Miami, but it probably happens in other quote high rent districts where there were all kinds of fees, and it was very, very difficult for tenants to move into the property. And some of these fees or costs, whether they're deposits or escrows, are perfectly legitimate. So if an owner wants a security, if the rent is $3,000 a month and the owner wants a security deposit of 1 month's rent, that's $3,000. And the association is entitled to up to 1 month's rent if it's document so provide. So that's another $3,000. So then right there and then that's $9,000 without including any of the other fees charged by the association. So sometimes when you hear these reports, they can be skewed to for sensationalism purposes. And yes, even if the numbers are high, they're not illegitimate. But in this case, they found that there were a number of community associations charging fees that exceeded the fees that were allowable by statute. And of course, they got into trouble for it. So you want to make sure that all of your fees or costs or deposits have been vetted and that you apply them uniformly.
So Lisa, really quickly, since we're talking about fees and the different associations, let's do our first poll question really quickly, if that's okay with you.
Yes, that'd be great.
And the first one is, what type of association is yours? And if you're on with us and you're a portfolio cam, let's use your largest one. So answer it using your largest property of your portfolio-ness. So here we go. It's the first question. So what type of association is yours? And once I see it slowing down, we'll share the results. And this will also help Lisa when she talks about some of the different scenarios she faced. We will know where to focus a little more on what type of association. Okay, it looks like it's okay. We still have them coming in. Right now, we're 76% condominium, 14% HOA, 7% co-op. We have 8 people here that's actually higher than I thought it would be, and 4 other. Okay, let's end the poll. Let me share the results. And here you go, Lisa. We have 14% HOA, 77% condo, 6% co-op, and 4% other.
Okay, I mean, and that's what I expected because on the HOA, they're not as intense when it comes to their screening process, although, I mean, many are. So this gives a perfect opportunity to answer some of the questions that have already been posed onto the site. And the governing, for when it comes to fees particularly, there was a question: if the governing documents stipulate a dollar amount, is the association tied to that amount? Well, charging the fee that is permissible by statute would not be considered a statutory violation, but you're contractually bound by your own governing document. So if you have some artificially low fee, just like when it comes to late fees by statute can be up to $25 per month or 5% of the amount of the delinquent installment. I regularly see governing documents that allow for a $10 late fee, $15 late fee, or some other amount. You're constrained by those governing documents, and that's a perfect opportunity for you to make some changes to come into current day requirements. Now, there's a very, very important question about the interview, and we're going to talk about the interview process. But what happens if you found out that people are lying during the interview? Well, I can test you the best laid plans don't always allow you to account for everything, but it would be very, very difficult. In fact, practically impossible, depending on what the misrepresentation consisted of, to undo the transaction. Because think about it, you have somebody who paid in connection with the sale, you have somebody who paid X amount of dollars, somebody who received X amount of dollars. The person that received those dollars may have spent that money on another property, and undoing that whole transaction creates a lot of legal complications that would not otherwise be palatable to community association operations. So the answer to your question is you have to do as much homework as you can in advance. And if you find that there are inconsistencies or misrepresentations, then you're not precluded from having the person attend a second or supplemental interview, so long as you remain within the time period, so the time constraints of your governing documents. Jeff? Anything?
Well, yeah, before you get to the next question, that question you just answered is a perfect segue to our second of 3 poll questions. We'll do the last poll question at the end, so I don't take up any of your more time. But if you're a community association homeowner, okay, if you're a homeowner in an association, have you ever served on your screening committee? And that could be current or sometime in the past. We're just curious, because that question lends me to believe that many of you have been. Look at that number, 62%. Well, you can't see it yet, but you'll see it in a second. Sorry, I have stats, you don't.
Now, even though it says screening committee, a lot of times the board does this themselves.
True.
And a lot of times, a lot of these functions are delegated over to management. But it's just as important, even if you do delegate it over to management, it's just as important for the board to understand what the process is. And so the board can keep track of, the timeline, and also keep track to make sure that there's consistency. But look, we got almost an even 59-41, a little bit
pretty close
in favor of the participation. And that may be because the 41% are already performing this function via their board service.
True. Well, back to you, either the some questions or back to the program. Thanks for letting me interrupt.
The application, because the applications that I see are basically all the same. Some of them come from the screening company, whoever you're using for your background investigation. Some of them are, just standard forms prepared by management for like all of their clients. And some of them are just, very, very basic forms. So where and this is helpful with respect to the interview, what I like to do is let's be specific on the application. I want to obviously know the number and the names of the persons who are intended to occupy the unit. You want to know about the intended use of the unit. Is it going to be a full-time residence, a part-time resident, a vacation type residence? Are you going to have family members visiting on a regular basis? Obviously, you want to know what vehicles. This is a tricky wicket, though, because you want people to disclose the vehicles they own, because then you can marry that information to your existing parking restrictions. If you only have one parking spot that's assigned to that unit, and you don't have any additional available spots for either second car rental or otherwise, then you're going to want to ask the applicants, hey, you only get one spot. What are you going to do with that other vehicle? And this is especially true if you have adult children or children that are of driving age, because even if they don't list the vehicle now, they very possibly may want to acquire a vehicle the year they become 16, 17, 18, or what have you. So that's one way to screen the application. What kind of vehicles do you own? Number and type. References, residential history. I like asking about the residential history and getting specific information. Why? Well, if they were a tenant in their previous property, their previous residence, you can call, if you need to, you can contact the landlord and find out, were they, did they abide by rules? Were they problematic? Did they have unruly guests? Did they, have parties every single evening? You have to have the consent to obtain the consumer report. That's what your screening company will give you. And what documents are attached, required documents. Obviously, you want a copy of the contract, whether it's a tenant, whether it's a lease or a sale, you always want a copy of the contract. You want to verify what the terms and conditions are of the sale. I can't tell you how many times, it's John and Mary Bongiorno, I'm looking at one of the names here, that are the applicants, and then you look at the sales contract and it says BFD LLC. Well, who are you screening? Who's going to be the owner? You want to know exactly who's going to be the owner. And in the event there's going to be a corporate owner, you're going to want to know who are the actual occupants, who's going to bear responsibility. Animals and pets. The reason I have a hyphen here is that you generally want to ask about ownership of animals. Why? Because service animals and emotional support animals are not considered pets. And I did have this situation once where the application says, do you own any pets? The person said no. The woman moved in with either a dog or a cat. I forget what it was. The association turned around and said, you lied to us. She says, no, this is my emotional support animal. It's not a pet. So I didn't lie. And there was a whole back and forth that happened. They ultimately filed suit claiming the association discriminated against them because they were not advised, the association was not advised of the need or a request for permission to maintain an animal on property. And then also in your application, track your use restrictions. I talked about the parking. If you only have one parking space, or even in an HOA, and you require, or you have 2 garage spaces and 1 driveway space, or 1 garage space, 1 driveway space, you want to ask what kind of vehicles they have, because some vehicles may not even fit within a garage. So if they have 3 vehicles, and only one of them can fit in the garage, and you have those constraints, you're going to want to ask where do you plan to keep these vehicles, and the contents of the application. The more specific you can get with respect to the application, the better able you are to ask questions at the interview. Some associations do have a formal appointment to the interview committee. It's nice if you do have a screening committee or you do have an interview committee. It is nice to have some kind of documentation reflecting where you appointed those persons, because in the event there is a claim, you want to be able to show to your insurance carrier, in the event there is a claim, again, worst case scenario, that these persons are authorized committee members and therefore are covered under the blanket of the client or the insured when it comes to claims. You may want to set parameters on who may be present for the interview. I never have an issue if the real estate agent wants to be a part of the interview. What about other owners? Are they entitled to be part of the interview? Well, again, other owners there sensitive information that's discussed in the interview that may not be accessible to other owners, so you may want to preclude other owners from just generally attending various interviews. You're going to want to have your instructor committee people to keep some kind of notes, even if the note was Sally, John, and Mary. The people showed up at 12:45 for a 1 o'clock appointment. We met for approximately half an hour, a little bit of notes about what you talked about, and then the time of departure. That way you show, if in the event you have to show consistency in the event of a future claim, well, then you'll have these notes showing, yes, we do conduct interviews. Here are the interview notes. Even if the notes were, people showed up on time, they seem nice. You know what? That's a perfectly adequate note to have. You need to avoid the fair housing pitfalls, and that's where we see the majority of claims. So you want to talk about relationship or marital status. In Broward and Miami-Dade and Palm Beach County, marital status is all protected. So it doesn't matter what the marital status is. You want to ask who are going to be the owners or the actual tenants, and who are going to be the occupants, and have that information specified. You don't want to ask about the ages of the residents unless, of course, you're housing for older persons community. If I get a lot of questions about, well, we can't do the background report because, this person is from a foreign country and they're only going to be using this property as a vacation residence. Can we ask them for a visa, or can we ask them for a proof of legal residency? No, you cannot. And if you cannot conduct the background report, whether it's financial or criminal history, within the financial constraints of the statute, you have to make a decision. Is it worthwhile to spend extra money to get an Interpol report or some other type of report from the foreign country? Or can you ask for alternative insurances? Many times people from South America, they won't have a problem providing you with some kind of verification of income and verification of account balances and what have you. A lot of the times those transactions are approved without any financing either, so that you have security in the unit. And then, can you get references from previous association leaders? I know previous association leaders, previous association managers may be hesitant and have some trepidation about answering questions about former residents or actually current residents. But if those questions are legitimate and not too intrusive, you may find that you obtain that information. Like, did they live there? Oh no, only one person lived there. The other person we saw maybe, once a year or once every other year. Do they have these vehicles that they claim? Do they have other vehicles? Things along those lines. Okay, let's move forward. Fair housing notices. I posted here the fair housing notice that is published by the Palm Beach County Office of Equal Opportunity. You're not required to have these posters in your office or in some other place, but it is advisable to have a fair housing statement either in your rules or in the application itself that basically just says, Happy Land Condo is a fair housing community. We do not discriminate on the basis of any of the discriminatory classifications. And you can even list them should you so desire. That goes a long way when in the event that there is a claim. No, listen, we're a fair housing community. We even say it right here. We've published an intent to talk about fair housing issues. One of the questions here is whether the manager or the board member prepares the estoppel letter and the mortgage fee and the mortgagee questionnaires. Many times, if you are engaged in a management company to manage your association, your contract with the management company will enable the management company or require or task the management company with preparation of the estoppel and the response to mortgagee questionnaires. And those contracts almost universally allow the management company to keep the fees that are associated with those tasks as an additional compensation to them for the work. Now, again, your contract should require those fees to conform to the statutes. We have a question here about arrest records. I think I'm going to defer on that because I think I do address that later in another slide. But a question here about interview conducted over the phone. Nowadays, of course, it's perfectly acceptable to conduct the interview in an alternative way, as opposed to having them physically appear before you. What if people are moving from out of state? Excuse me. Are you going to be a stickler and require them to actually physically sit in front of you for an interview? There are some associations that do. And I can tell you, if that is your policy, then you have to stick to that policy like white on rice, because otherwise any inconsistencies are going to be a red flag. But I always encourage my clients, especially in today's day where we're on a Zoom meeting here, you can ask questions, you can get a feel for how people are answering your questions, whether they're being secretive, or whether you think that they're being untruthful, or less than forthright. Those are things that you can actually evaluate over the phone. So what are the allowable transactions? I talked about this. Or what are the allowable options? Well, I talked about originally what's in your governing documents. So do your governing documents say that the transfer approval process applies to sales? Does it say it applies to transfers? Does it apply to leases, gifts, operation of law? Those are all different scenarios. Operation of law could be an inheritance. You may have different requirements, different procedures for each type, and your documents may omit. They may just say sale or lease, not address transfer by gift, meaning the spouse to another spouse, or parent to child, or child to parent, or friend to friend, or what have you. And there was actually a case about this that happened in the Ocean Reef community down in the Keys, Key Largo, where there was some history between this person and the association. It's not really clear from the case law itself, but the property was owned by a trust. The grandmother was the trustee of the trust, and they had owned it for many, many years. The trust then deeded the property via gift to the grandson, who was an adult. And the grandson was the person that had some kind of history with the association. The association rejected the application. It went to court. It went all the way through the appellate court. And the appellate court said, listen, your transfer approval procedures refer to sales. They don't refer to gifts. So you had no right to even ask for the information that you asked for in connection with the transfer approval. And you also had no right to reject the application. So what are your options? Well, you can approve. If you approve, everybody is happy. The transaction proceeds as contemplated, the people move in, the old people, move out, or they buy their other place. If you reject, are you required to produce a substitute? And a lot of the time that depends on not only the terms and conditions of your governing documents, but whether approval of the application would result in an automatic violation of the governing documents. So easy examples that I always say, if you're a HOPA, Housing for Older Persons community, and there are two 30-year-olds that want to purchase and move in by themselves without a person of age, your documents require at least one person to be age 55 or older. Well, you can't really approve that application, because by approving that application, you're approving a violation of your governing documents. And then there's a waiver issue if you try to go ahead and enforce the governing documents, because you have a non-conforming use. So that is really why you want to have the uses that are contemplated by your declaration in the application, so that you can ask those questions. Who's going to be living here? And what we've seen, and what the trend has been for at least the last 10 years, is to add in, quote, good causes. And you do this via amendment. Unless you're a relatively new community, you may have some good causes to reject the applications. But good causes could be a history of financial irresponsibility, a history of violent crime, a history of disruptive behavior, even in that association as a tenant, or in other properties of which you're aware. And those good causes, if you rely upon them, generally you will not be tasked with providing that substitute or purchasing the unit. Now, there's a question here. It says, we've been told by legal counsel there's practically nothing that we can deny a tenant for. And if that's the case, why do you screen? Well, it may depend on your documents, may be very, very limiting. And if they are, that's something that you can address and that you can amend. But tenancies are scrutinized far less than purchases. So there are tenancies that may be rejected possibly for credit history, credit score, again, history of violent crime, and other criteria that are perfectly acceptable and that are not as heavily skewed towards the purchaser. I mean, not as heavily skewed in with respect to a sale, because you're not protecting really the right of the current owner to sell. You're only basically screening somebody to see if they are adequate or suitable for residency within your community. So again, for that person who asked that question, ask whether you can amend, why can't you amend, and how come we can't have criteria? I mean, criteria as easy as there's a 1-year waiting period before leases can be approved. Well, then you're rejecting everybody who's going to ask for tenancy approval within the first year of ownership. Vehicles are a very good one, a very frequent example when it comes to tenancy approvals, because if you only have one parking spot dedicated for the unit and there are 3 cars, well, you may have to reject that occupancy in that tenancy because there's nowhere for them to park and they haven't provided you with any alternatives or information indicating that they made arrangements for alternative parking. So the procedural considerations are, we talk about in this slide, who has the authority to make a negative decision, even if you're delegating your processes or the actual logistics to management or to a screening committee. Do you want to empower them to make a negative decision? Most of the time, no. Most of the time you're going to want, and I would venture to say, I would want the association to have that decision-making come back to the board. If everything is fine, the screening committee approves or management approves, you don't have any complications. But if there's going to be a negative decision, you want that to come back to the board of directors so the board of directors can take action. Is a meeting required for the board of directors to take action? What can you discuss in an open forum? Remember, boards don't just take action by someone saying, yeah, that sounds fine on the phone when the manager calls. You know, board action is either appropriately delegated to one of the officers, or you need to have some type of a board meeting or board resolution. You know, and that's my third procedural consideration. Can the board even adopt a resolution without a meeting? You know, is the board required to furnish that substitute? And who sends the notification of the decision? To whom is the written notice sent? Well, you always need to notify your current owner, whether it's a person that wants to sell their unit or wants to rent their unit. You always have the obligation, since your fiduciary relationship is with that current owner. But many of the counties also require the housing provider to notify the tenant of a negative decision. And if you're notifying the tenant of a negative decision, you have to have some type of reason for the decision making, which then brings us to the human rights audit ordinances that I talked about, that requires you to reply to the applicant within the 45 days of the decision. But if you're basing that decision, here's where I wanted to get to, on information that was obtained in the consumer report, whether it was a criminal history report or the credit report, you are required under the Fair Credit Reporting Act to send what's called an adverse action notice. If you're using one of these screening companies that is very familiar and they do a lot of the tasks for you, I think Tenant Evaluation goes ahead and sends the adverse action notice to the parties to the transaction. They automatically include the name, address, and phone number for the credit reporting agency and a copy of the notice of consumer rights. That's something that's often omitted. And if you're using a good company that handles some of the logistics, that should be taken care of for you. But it is a kind of a red herring because it could get you in trouble even if you didn't do, quote, anything wrong. Let's try to move through this and then I can get to additional questions. Document management. What do you do Fair Credit Reporting Act. What do you do with with these consumer reports? You know that they're not accessible to members. You know that there are statutes that create liability for cyber release of information through cyber. So, and everything nowadays is done via computer. So management or the credit reporting agency is emailing either the management or the president a copy of the consumer report, or you're signing on to a portal to see a copy of the consumer report. You're downloading that report onto your own personal devices. Should they stay there? No. You need to keep you need to retain a copy, and you need to segregate it in your file with respect to that unit, so that you have the information that you can show that you're being consistent and that all applications are processed similarly, but you want to do so in a way that maintains the privacy of that information. And you don't want to have individual owners, whether they're board members, managers, other people, having this information on their private devices, or if they print them out and just leave them on the kitchen table, or they leave them at Starbucks or something. You really need to be cognizant of your record keeping and where these records are. I say there, section 501.171, that's the liability for release of personal identifying information. That those consumer reports can have a lot of personal identifying information. Rejecting the transfer for good cause, we talked about this. So what are good causes? Criminal history, violent crime. I say here, I put in my slide the HUD guidance memo 1 or 2 years ago. Maybe it's 3 years ago, HUD did issue a memorandum equating or indicating that reliance solely on a criminal history could be fodder for a claim for disparate impact discrimination. What does that mean? Okay, that means if your actions to reject anyone that has any criminal history whatsoever adversely disproportionately impacts people that are otherwise protected or in protected classifications, whether it's race, whether it's national origin, whether it's religion, or what have you, then that action in and of itself, even though there's no intent to discriminate, and even though you feel you're acting uniformly and consistently, can constitute discrimination because it's disproportionately impacting people within a protected classification. Now, what do you want to see? What do you want to rely upon in criminal history, or what do you want to avoid when it comes to criminal history? Well, you want to look at the nature of the crimes, and the remoteness. When did these crimes occur? But I also want you to understand that the report that you receive is not necessarily complete. A lot of times I look at these reports and then I actually look up the records through FDLE, Florida Department of Law Enforcement, or other sources. And I find that the cases had, even if there were probation served or there are fines that were paid, there's what's called a withheld adjudication. Well, that means the person that was accused of that crime was not adjudicated, was not found to be guilty of that crime. The adjudication was withheld. So reliance upon a withheld adjudication is very speculative, is very suspect. You want to see how frequent, were the activities for which this person was accused of crimes. Are the actual crimes themselves something that could impair your community association operations or your residents, and particularly if you have elderly residents and there was certain types of fraud that was committed, and of course violent crime or other types of crime that could jeopardize the health and safety of your residents are always going to be considerations you can take into account, so long as your documents do allow you to reject and allow you to reject for good cause. Financial history, credit score. I discourage associations from having an absolute credit score requirement. There's always different ways for people to show that they have the financial wherewithal to absorb all of the costs and expenses associated with ownership of the unit in addition to their, to their life. But they're having a range and then asking for that additional information is perfectly appropriate. And conflicting with the covenants, that's basically what I said. Intended use is inconsistent with the governing documents. They want to they want to run a meth lab from your condo unit. No, again, they're not going to say that on their application. But failure of a condition precedent, did they, do you have a 10% down payment requirement? Did they put the 10% down payment in? And evidence of previous conduct. If you're going to rely upon previous conduct, you need to have verification or reliable information that that addresses that previous conduct. Now, there's a question here about one tenant had 2 social security numbers. Any suggestions? I can tell you, I had 2 social security numbers and I didn't know it. I was using from approximately age 16 or 18 through when I applied to become a member of the Florida Bar. I used the wrong social security number. And I didn't know. I mean, I just wrote it down. That's what I thought my social security number was. So then when I applied to the Florida Bar, they told me that I applied using the wrong social security number, almost, wanting to investigate whether there was a fraud. And then I discovered that I was using the wrong social security number. So again, these are questions to ask in the interview. That's exactly why you have an interview. If there are crimes or criminal history reported, there's nothing wrong with you asking about the circumstances of that. I mean, somebody has a DUI or, possession of drug paraphernalia. Oh, I was in college and we were in one of the dorm rooms and we had all the stuff there and we were raided. There could be reasonable explanations for some of these criminal history. I'm talking fast. So specific issues, what if the association has specific criteria? Again, this goes to what you're going to ask on your application and what you're going to ask about if in the interview or with respect to additional requests for supplementals. So hot topics, transient uses, we're practically finished with our slides now. I can actually talk about some of the questions that are on here. Okay, so here's a hot topic. Actually, do I have it on my list? No, I do not. But one of you raised a hot topic, Section 8 applicants. Is it illegal to reject an applicant based upon source of income? And in Broward County and Miami-Dade County, there's something called source of income discrimination, meaning the rent is going to be paid because it's paid by a third-party payer, does not give you the right to say, no, you don't have the money to pay your rent. We're going to reject you solely on that basis. So you have to take that into consideration when you are reviewing these applications. Now, I can say, before the source of income discrimination was enacted into the actual ordinances here, well, in Broward County, where I practice mostly, I did have a third-party purchaser tri-party addendum that basically guaranteed any of the obligations if there was going to be a third-party payer. And at the time, I was thinking a parent pays for their child. I mean, if it's a 21-year-old and they're moving into a condo as a tenant with a friend and they don't, they have a sketchy kind of financial history and maybe, not such stellar jobs, but the parent is going to pay. I had that addendum that basically made the parent a guarantor. You can't do that when it's a Section 8 applicant. Something to pay attention to. I like one of the items here, or someone raised, do we have a template to check off items to cover in the interview? Dog, confirm, buyer, tenant. Well, you can use this PowerPoint presentation, for which you can download yourselves, or you can contact us to get a copy of it if it's not easily gleanable how to download it. But really, that checklist comes from your rules, your use restrictions. Okay.
Lisa, right now you're answering questions. Is that correct?
Yeah, that is correct.
Yeah, just give me a half a second here, just because in order to get your credits, you don't have to stay on for this part since you got through the presentation. So before anybody chooses to leave, even though I hope you don't, Lisa's got some great information on answering these questions. But really quickly, I'm going to take over the screen sharing for a second, Lisa. And over here, if you do need to run, when you leave the webinar, you'll get a link. You click on the link, it takes you to this page. You fill out the evaluation. At the top here is where you can click here to download the course outline that Lisa just mentioned. These are the slides. So if you click on that, that's what happens. You'll see they open up here, and then you can go ahead and save them. And then once you fill out the evaluation and hit submit, your confirmation screen looks something like this. In the shaded box area, it forms a certificate. So you can then right click on it, save as, print, send it to your printer, take a picture of it with your smartphone and save it that way. So you have a variety of ways you can save this certificate. So again, that's if you have to leave now. But Lisa, back to you to answer some questions. Thanks for listening, everybody.
Yes, thank you. Thank you so much for your time today. Hot topics, again, lease versus license, defining what transient use is. Everybody's very, very concerned that the properties are going to be advertised on VRBO or Airbnb and the like. You may want to enact restrictions against advertising so that if you find those advertisements online, the actual advertisement itself constitutes its own violation, as opposed to having to prove that you did have guests that came through the transient website. And ADA considerations for those transient if you have some public use. For the certificate of approval, you want to identify the approved buyer. We talked about that earlier. So if the approved buyer is Lisa LLC, then that's okay. You identify Lisa LLC as the approved buyer, and that the lender will want that on the certificate of approval. You will also want a separate document that identifies who are going to be the occupants or the primary occupants in the event you have some kind of an entity that's the buyer. For signature authority, again, management does this routinely. So if you could just delegate to management the ability to sign certificates of approval, that's advisable in my opinion. Do you need to waive the right of first refusal? That's a question that you really want to ask your counsel in connection with a particular transfer application.
Earlier on, somebody asked a question. They were a little confused about the definition of right of first refusal. Can you also explain that when you're done answering?
Okay, got it. So when you're reviewing a transfer application, a sale application, so if it's an arm's length transfer, I put it on the market, somebody gave me an offer, there's a contract for the sale. So a right of first refusal or a right of substitution requires, if I want to reject the purchaser, and it could be for any reason. I often use the Bertie Madoff example, or Bertie Madoff's wife example. Maybe you don't, she's got all the money in the world, or I don't know how much money she has anymore, but you don't want her in the building. Well, if you want to reject someone for no reason like that, and it's not based upon a discriminatory classification, remember, then you can exercise your right of first refusal, which means that the association will purchase the unit under the same terms and conditions as was offered to the original purchaser. So a right of first refusal does not give you the opportunity to come in and try to renegotiate everything. You're basically saying, no, we don't like Mrs. Madoff, we'll just buy it from you, you're whole. A right of substitution is the same thing. Instead of the association taking under that contract, now you're delegating it to a third party. Hey, we don't like Mrs. Madoff, and I apologize to her, I don't know anything about her, but again, we don't like Mrs. Madoff, or we don't like this problematic movie store or athlete because of all the history of problems they've had into. We're going to, I know my neighbor from Massachusetts really wants to buy a place here. I sent them the contract. They'll buy the place under those same terms and conditions. So that's what the right of first refusal or the right of substitution. I think I did see a question. Can they refuse to then sell to you? And that also depends on the documents. A lot of times, the owner can just withdraw the transfer approval application, saying, okay, I'm just withdrawing it. I'm going to keep the place and I'll put it back on the market at some point. in other situations, depending on the document, they have to go forward, and the association or the third party purchaser will have rights of specific performance, meaning that you can actually sue to force them to sell to you. You can't do that if there's other considerations. It has to be a fair market, arm's length transaction. You can't do that if it's my cousin from, my husband's cousin once removed, and therefore I'm going to give him a break, that kind of a thing. No, you can't jump in on a good deal solely because there's some kind of relationship. Somebody asked about the background report and what do you do with the sensitive documents? Retain them, definitely retain them, but segregate them in the file in some way. So you may have, most associations keep unit files, and I'd like you to keep unit files, even if they go back 1 or 2 transactions. So you can have a sealed envelope in your unit file with the sensitive information. That way, the information is there, and someone will know if it's been accessed, and it's only accessed when it's necessary to access. And I say calendar eligibility for lease. That is in the case if you have some kind of a waiting period, or you are operating under a cap, and there's only certain slots that become available. And then obviously after the transaction is complete, you want to verify the occupancy. What time is it now? So we're good on time for a couple of more.
Sounds good.
Okay.
And once again, folks, we're staying a little over time to answer a couple of more questions, but if you have to go, we understand. And when you do leave, please click on that link for the evaluation, and then you can get your certificate and download the slides. Back to you, Lisa.
Okay, well, does the association have to disclose its governing document to anyone off the street simply because they asked for it? No, it does not. First of all, many of these documents are public records. They're recorded in the public record, so anybody can go obtain them themselves. Governing documents are available to tenants. Certain governing documents are now available for tenants for inspection. They're always going to be available to owners. And yes, you can charge your actual costs for photocopying the documents for your actual owners. So if an owner wants to make 25 copies of the governing documents because they want to distribute them on the corner of Commercial and A1A. All right, well, that's their prerogative. There's nothing secret in these documents anyway. As I said, most of them are recorded in the public records. There's a question about dealing with your management company. The management company is using your employees to do most of the paperwork for the screening, and they are collecting the fees for the estoppel. Well, remember, you have a contract with them. So you have to honor whatever you agree to in your contract. And when you say, quote, your employees, are those employees of the management company, or those your separate employees that have been tasked by the management and company to perform certain services? So if they are your own employees, and if their job responsibilities do not involve dealing with transfer approvals, doing some of this paperwork, or any of the financial operations, then they're not going to be capable of issuing the estoppel. But again, check your contract with those. What does it mean to the board would have to provide a substitute? I think I kind of answered that. Can you reject if you have a substitute? That's where you can reject. If you have a substitute and your documents allow that, or the right of first refusal, then you don't have to have a reason. The person could have smelled bad when they came in. The person could have been wearing the wrong kind of shoes. As long as your decision is not based upon a discriminatory classification and you're going to make the current owner whole, then you have a lot of leeway there. Of course, a rejected purchaser, or particularly the real estate agent, may be perturbed and think that your no reason is really a subterfuge for some discriminatory reason. So you have to have all of your ducks in a row. But that really is the saving grace to the rejection option. Can we insist on interviewing owners who inherit the property through a trust with police credit checks and et cetera? That goes back to the authority question I mentioned earlier. What does your transfer approval procedures say? What did they say? Do they say lease? Do they say sale? Do they say transfer? Do they say transfer by operation of law? Do they say, you know, transfer upon inheritance? Typically with an inheritance, it's not the same exact approval procedure. It's most of the time it's an after the fact approval procedure because it's an inheritance and because the transfer is through operation of law. And if it's a trust, in this particular case, it's a trust, the ownership itself is not changing if the trustee names a new beneficiary or the trustee changes. Remember, the trust is a legal entity. It could be the owner. So you'll have to have procedures in your governing documents for you to be able to interview or conduct screenings on occupants rather than solely owners or the named tenants.
One more.
Yeah, let me scroll down because
Okay. And for those of you still with us, thank you. We see over 100 of you are still here. Be sure to visit kbrlegal.com. Check out our calendar. I think next week we have, almost a week from today, we have an HOA board member certification class. So let some of your fellow board members know that this course is coming up, and you can get your certificates instantly after you take the course.
yeah, so there are a lot of questions about record keeping and otherwise. As I said, for cyber purposes, once you as an individual owner, as an individual board member, no longer need the record on your personal device, my suggestion is to delete it. Now, again, for the association's purposes, you need to retain those records. You need to maintain it in a way that it does not become easily accessible to others. But there's no reason that you as a board member need to retain that on your personal device. And if you lose the phone, lose the iPad, lose the computer, and now all that information that you've been storing for the last 3 years that you've been on the board falls into the wrong hands, well, there could be liability associated with the release of that information. There was a question about delegation of authority and whether it should come back to the board if there is going to be a rejection. That is always my recommendation. Unless you have a very sophisticated and screening committee that you've worked with for years that is on the same page and that understands and that has the ability to contact counsel to ask questions, I always want that rejection decision to come back to the board of directors as a whole. Now, with respect to tenancies, I said the restrictions are a little bit looser. So if you have pre-approved reasons that are good causes for rejecting a tenancy, then you can delegate that authority to management or to your screening committee, because they already know. Like if someone wants to rent a place, they have 4 cars, there's only 1 car available, or if someone wants to rent a place, they don't meet the occupancy restrictions. So really what I wanted to impart here today is that this whole screening thing, it's replete with pitfalls, potential pitfalls. And the best thing that you can do is to make sure that you have your ducks in a row in advance and that the people know what they're doing, so that you don't fall into one of the pitfalls that you could have easily avoided. That being said, I want to thank you for joining us today. I definitely want you to make sure that you fill out the survey so that you can receive your credits if you're a licensee, and so you can print your report and show it to your mom and proudly display it on your refrigerator if you're a board member or an interested volunteer. So thank you again. I think Jeff already said it, the slides are available for download, or if for some reason you have difficulty doing that, just send either one of us an email and we'll be happy to send you a copy of the presentation.
Thanks, Lisa.
Thank you.
And for those remaining, I did make a promise I would show it just one more time just to help anybody out who is having difficulty. When you leave the webinar or when we end it, you get a pop-up. The pop-up will contain a link. Click on the link. It takes you here. At the top is where you can click to download the slides, fill out the evaluation. It's not as long as it looks. It's pretty quick. Hit submit. After you submit it, the confirmation screen looks like this yellow shaded area has your name, the course number, everything you need, Lisa's digital signature, the DBPR's address, everything you need on the certificate, just in case. You can right click on it, save it, print it, photograph it, and you get it instantly. And again, if you're techie challenged, like Lisa just mentioned, email us and we'll send you one. The same link, if you don't want to do it now, the same link will appear in a follow-up email that everybody will receive tomorrow. That's especially important for anybody on the phone listening to us now. You will not see the link if you're on the phone. So if you're on the phone attending today, look out for that email tomorrow, sent to the same address you used to register for this course. So on behalf of Lisa, Kay Bender-Rembaum, and myself, thank you very much for hanging out with us tonight. Let's go to dinner. Good night, everybody.
Thank you. Bye-bye now, everyone.
See ya.